after a report by Jane Corbin for Panorama.
A man's arrested and tried for selling machines to arm Britain's enemies. Now an inquiry's revealed the government sanctioned his actions. Tonight, Panorama asks, did innocent men face jail to save the government's embarrassment? British intelligence watches and listens as a group of Iraqi businessmen come to the Midlands to buy a long-established engineering firm. It is 1987 and Saddam Hussein, after a decade of bloody conflict with Iran, is building his own weapons industry. He needs machine tools, and his agents buy the Coventry company Matrix Churchill. Its managing director, Paul Henderson, signed contracts worth millions to supply machines to make arms.
We were making components that would eventually be assembled into munitions like 155 artillery shells, 122mm, and 80mm mortars.
But Henderson's sales manager was telling a British intelligence agent exactly what the firm was making for the Iraqis. The information was passed on through Whitehall.
I told him everything. I took the whole file down to one of the hotels in Coventry where we used to meet.
Matrix Churchill's military contracts caused alarm in Whitehall, where export licenses had been issued for civilian purposes. Henderson went to the Department of Trade to meet Alan Clark. He knew the minister's robust views on trade.
My responsibility is for the people of this country and for their welfare, their prosperity, and I feel that I'm not particularly bothered about who we're trading with, providing we get paid, and providing the economic, the industrial and labour consequences in Britain are favourable.
His attitude was one really of, well, if the Germans and Swiss are doing it, you know, it's important that we get a slice of that business.
And the background was the knowledge on both sides that these machines were destined for munitions manufacture.
Oh, absolutely.
Later on, Henderson was prosecuted over similar contracts. Now an inquiry is examining if the prosecution was right. Lord Justice Scott was appointed to conduct the inquiry, assisted by counsel Pressley Baxendale. They've examined reams of Whitehall documents and questioned scores of people to get to the truth. But according to one civil servant who gave evidence, the truth is a difficult concept. Tonight on Panorama, with the help of actors, we'll be recreating key moments from the inquiry and taking you inside the secret workings of government. Lord Justice Scott has raised serious questions about whether ministers and civil servants misled Parliament and shaped a criminal case against 3 businessmen in order to cover up their own complicity in a covert policy to provide Iraq with machinery to make arms.
I thought I was unshockable. What I have heard on several occasions already as a result of the Matrix Churchill trial collapsing has shocked me time and time again. In my worst moments, I wouldn't have thought quite, to be honest, that it could have happened like this. That those on the inside could have been so casual about the fate of other people's lives.
In 1988, Iraq's war with Iran drew to a close. But Saddam had unleashed poison gas on his own people, killing thousands in Kurdish villages. In Britain, there was outrage, revulsion, demands to continue tight export controls of defence equipment which could bolster a murderous regime. Against this background, 3 ministers met to discuss changing the published guidelines which prevented military exports to Iraq. The ceasefire meant British companies wanted to take advantage of a lucrative market. The ministers were Alan Clark from the DTI, Lord Trefgarne from the Ministry of Defence and William Wargrave from the Foreign Office. They decided the only exports that would now be forbidden were those
of direct and significant assistance in the conduct of offensive operations.
This was a recognisable change in policy. Arms exports would still be banned, but not machines to make arms. The ministers kept the change secret. Mr. Wargrave's private secretary minuted the other two ministers.
Mr. Walgrave is content for us to implement a more liberal policy of defence sales without any public announcement on the subject.
From now on, a covert policy was in place in Whitehall. 2 years later, when barrister Geoffrey Robertson came to prepare a defence for his client, Paul Henderson, this change in the government's guidelines was still secret. Only after a legal battle to win the release of Whitehall documents did he discover the rules had been changed.
It suddenly hit me that this badly photocopied document was in fact the smoking gun for the case for the prosecution, because it showed that the government had not, as I thought I might have to suggest, conspired to break its own guidelines. It had, on the contrary, secretly, without telling Parliament or the public, revised those guidelines so as to allow secretly exports of this kind, exports of Matrix Churchill type machine tools geared to make armaments, geared to provide Iraq with its own bomb-making potential.
Ministry of Defence official Alan Barrett told the Scott inquiry that ministers and civil servants feared a public outcry if British export policy helped Iraq build up its war machine.
You need no public announcement, because as soon as you have a public announcement you get trouble because of the public perception of Iraq and the Kurds.
Yes, indeed.
In that way, they wanted to be able to change the policy, but they knew that if they announced the change, there would be trouble, because there was a vociferous group of people, both Parliament, press and public, who would feel that any change towards Iraq should not happen.
Yes.
Does that sum it up?
Yes.
And is that how you understood it at the time?
Yes.
More devastating evidence of Saddam's use of chemical weapons began to emerge. In the House of Commons and the Lords, many questions were asked about the policy of exporting defence equipment to Iraq. Those who asked believed they were not told the truth.
Guidelines had been changed, and as far as I'm concerned, if such guidelines are changed, it ought to be done publicly. To do so secretly, and then to deny in answers to questions such as mine that such changes had been made seems to me to be corrupt.
Lord Justice Scott has questioned William Wargrave, a key minister in the decision to secretly relax the guidelines. He denied Parliament had been misled and argued that because there had been no public announcement, the policy hadn't really changed. Scott was unconvinced.
The outrage about what was happening to the Kurds was a proper and natural response. Is it not a healthy feature of a mature democracy that issues of this sort can be debated? And they certainly cannot be debated if the subject matter of the debate is not made known.
But it is also, Sir Richard, a definition of what a mature democracy means. I think that it knows, particularly from time to time in relation to foreign affairs, it is going to be necessary for everything not to be said in detail.
If it's one of those grey areas where full disclosure, because of particular sensitivities, isn't possible, what you've got to strive for is to give as much of the picture as you can, but in such a way that it doesn't distort the whole, that it isn't deliberately misleading or deceptive.
And do you think what they were told was misleading? What Parliament was told by ministers was deceptive and misleading?
To be told that the guidelines had not changed when they had, I think, amounts to deception and to the misleading of Parliament. I can't see it in any other way.
The absence of publicity is often essential to the conduct of good government, often essential to the safety of British subjects, and those are the matters that have to be balanced.
But at the time there was considerable public disquiet about the gassing of the Kurds, and I think the point that Lord Justice Scott is making is, given that public disquiet and what amounted to a change of policy, there should have been some debate about it.
Well, there was debate about it. We answered questions about the gassing of the Kurds in Parliament on a number of occasions. But there is a limit to the extent to which one can discuss changes in policy of this kind.
During 1989, business boomed for Matrix Churchill. They were providing machines to Iraq, machines to make components for sophisticated fuses, for shells and artillery rocket parts. On their license applications, the company wrote General Engineering as the purpose of the machines. The government approved the licenses, though Iraq's arms procurement efforts were well known. As Eric Beston, the DTI official in charge of the licensing unit, acknowledged to a minister, the military application of the machines no longer concerned the government.
Even if the machine tools were intended for munitions manufacture, there was no longer sufficient reason under the ministerial guidelines to prevent export.
Lord Justice Scott has established that licenses were given despite British intelligence warnings to Whitehall about the Matrix contracts. In October 1989, a GCHQ report revealed a company was sending machines to Iraq to make fuses, and the company was confirmed as Matrix Churchill. Despite the intelligence information, the government approved the export of these very machines. Yet the government prosecuted Matrix over this same contract. The company's machines were dispatched to Iraq's Scud missile program, yet intelligence had warned of this too. By 1989, Henderson himself had been recruited by the British Secret Service. His contact used the alias John Balsam.
A meeting was set up and he visited the factory in April, 24th of April 89.
Henderson was a low-level source, one of dozens run by the young Secret Services officer.
My contact, John Balsam, visited me on a number of occasions, and this shows the record of him visiting me on the 27th of October 1989, and he was here for a period of 2 hours.
Henderson's value to intelligence lay in what he told them about Iraq's procurement of nuclear and missile technology. There was less interest in the conventional munitions that Matrix was making. On one trip to London, Henderson brought them a coup, the plans for a rocket to be fired from the supergun. The intelligence services were waking up to the scale of Saddam's arms network. By 1990, Iraq's activities were arousing alarm in Britain and across the world. Saddam Hussein was arming to the teeth. He flaunted his acquisition of nuclear triggers. The supergun was seized. And journalist Farzad Barzoft was hanged in Baghdad for investigating weapons sites. In April, John Balsam went back to Coventry. He had information Matrix was involved in nuclear contracts. Indeed, Henderson had drawings, but denied that he knew the project was nuclear.
If I was trying to hide something as to what it was being used for, why would I give them drawings of the components?
Did you know it was a nuclear project?
No, we didn't know at that time.
Balsam's secret reports, produced at Henderson's trial, make it clear that the intelligence services were suspicious of Henderson's activities.
Our source is withholding the complete truth from us about this subject. Matrix Churchill undoubtedly have some skeleton in their cupboard.
Intelligence were growing disillusioned with their source. They were preparing to drop him. But now, in June 1990, a new player entered the scene. Customs came looking for something illegal.
Just on the outskirts of Coventry,
Customs officers had received a tip-off from Germany that Matrix was sending machines to make arms in Iraq, machines which the company had claimed were for civilian uses. What customs investigators didn't appreciate was that another branch of government, the DTI, which issued the licenses, had known in 1988 that the company was engaged in munitions work in Iraq and had still approved the exports. And customs, like the rest of the country, were unaware the government's guidelines had been liberalised, allowing machine tools to be sent to Iraq. DTI official Michael Coolican has told the inquiry of his ministry's consternation over customs' determination to investigate Matrix exports. The DTI had been told what the machines were for and had issued the export licenses.
Somehow the equipment was allowed.
Yes. Equipment was allowed to go despite intelligence reports. Therefore, if customs did what they were expected to do, go and ask questions, they might quite easily bump into incriminating evidence that related to those exports, and would therefore wish to pursue those. Indeed, as I understood it, would see it as their duty to pursue those. Therefore, quite clearly, issues might come out in court relating to the fact that the government had known about these intelligence reports and nonetheless had decided to allow exports to proceed, despite the intelligence reports.
In the urgent memo he wrote, Michael Coolican asked,
"Are ministers willing to have the 1987 and subsequent decisions made the subject of courtroom argument?"
He went on,
"The dirty washing liable to emerge from the action proposed by Customs and Excise will add to the problem posed by the gun. For the DTI, the timing is extraordinarily embarrassing."
William Wargrave, Member of Parliament.
For government ministers, it was turning into a long, hot summer. At drinks with Iraq's ambassador, Mr. Wargrave was sociable.
This house used to be my sister's house. Yes.
But British businessmen there knew that relations were souring. Iraq had protested over the seizing of Supergun and threatened a trade boycott of Britain. Hostility was building between the DTI and Customs, and a furious turf row broke out in Whitehall. The Scott inquiry has heard a DTI official, Michael Petter, explain why he launched an extraordinary outburst against the Customs investigation at a high-level Whitehall meeting that July.
Were you hoping to persuade Customs to conduct themselves differently?
I think they had gone about some of their previous raids, I will call them visits, in a rather gung-ho way. There had been a fair amount of press reporting about them, and that seemed to have got under the skin of the Iraqis. I felt that, and I did say this, that obviously they could not pursue evidence that they had got, but there was more than one way of killing the cat, as it were.
Whitehall was clearly nervous about the Customs investigation. Telegrams were arriving from Baghdad warning of anti-British demonstrations. On the 19th of July, a meeting was convened here at the Cabinet Office, chaired by the Foreign Secretary Douglas Hurd. Despite Saddam's saber-rattling on the border with Kuwait, ministers at that meeting decided to abandon almost all controls on the export of machine tools to Iraq, essentially bringing public policy into line with what they'd been doing secretly for 18 months. The rug was being pulled from under Customs' feet. There'd be no point in pursuing Matrix any further. Then suddenly, overnight, the world changed.
Iraqi troops have invaded Kuwait and are reported to have taken
behavior intolerable.
It is a total violation of international law.
Started moving forces towards the Gulf.
His troops will turn Kuwait into a graveyard.
They have to take a large number of casualties.
Baghdad is gathering nuclear technology,
which we have supplied for profit.
I think that had he not invaded Kuwait, the prosecution would never have ever gone ahead against us. I think it was more to, in some ways, to cover up the embarrassment that it could cause the government, or they thought it would cause them, if it became common knowledge at that time that the government had supported British machine tool companies in supplying machines to munition-making plants.
On the 16th of October, Customs returned to Matrix Churchill. This time it was not a visit but a raid.
In position. You ready?
16 officers arrived in 6 cars at the Coventry factory. They sealed off the entrances so that no one could leave with any papers. Customs believed that Matrix executives had broken the law by not declaring on their license application forms that the machines were designed for making munitions. The investigators were interested in 2 particular contracts, a project to build artillery rockets and a fuse contract, which intelligence had warned of in October 1989. Licenses had been issued by the DTI for both. Customs were not concerned whether the DTI had sanctioned these licenses and what they had known. They were only concerned about the actions of the Matrix executives. Henderson was arrested and later released on bail. No charges as yet. Customs believed the DTI had been lax in its export control, and as an independent prosecuting authority, Customs were determined to pursue a company they believed had broken the law. After they left this factory, the Customs investigators were to become more and more aware of just how much the government had known about the military nature of the Matrix contracts, the parts played by individual ministers, and how civil servants, under the secretly relaxed guidelines, had seen no reason to stop the exports. In the coming months, a prosecution case was shaped which minimized these awkward facts.
What they were forced to do, and what they actually did do, was to shape a case against the Matrix Churchill defendants, which was actually divorced from reality, which was actually one step removed from the facts. They shaped a case which distorted the reality and hoped, and I have to say this, hoped that by distorting it and by persisting in that distortion to bring home a conviction.
Customs needed confirmation from Whitehall that Matrix had acted illegally before they could bring any charges. Eric Beston of the DTI was key to the prosecution. He provided Customs with a witness statement, but he kept hidden the government's secret change in its guidelines. He underlined his omission in a memo to his superiors.
You will see that I have made no reference to the slightly more relaxed ministerial guidelines adopted in December 1988, but as far as I'm aware, never publicly announced.
But he was worried about how he could reply if the defense asked him whether he had known Matrix machines were destined for munitions manufacture.
I could not claim that the government knew nothing, but equally, at the moment, I am not sure how this question could be answered honestly without causing some embarrassment at the very least.
At the Scott inquiry, Eric Beston, who was head of export licensing during the relevant years, admitted that he had indeed left vital information out of his witness statement.
I quite recognise that I should have insisted on putting a reference to the revised guidelines in here.
Lord Justice Scott seemed to suspect that Beston had not acted alone in deciding not to mention the policy change.
I noted you said just now to Miss Baxendale, I should have insisted.
I should have made certain that I did.
It was not that anyone had suggested it in the first place.
Not that I recall.
With the statement from the DTI, Matrix executives were rearrested and charged with export violations in February 1991.
It was really, I guess, when the cell door shut, that it suddenly came home to roost that this was for real.
Customs set off to speak to Tony Stedman, the civil servant who'd actually issued the Matrix licenses. He had seen the GCHQ intelligence, but his witness statement said he was aware of no evidence about the machines going to manufacture arms. His carefully tailored words had been amended 3 times on the advice of government lawyers.
At the inquiry, Lord Justice Scott asked Tony Steadman why he'd altered his witness statement and what advice he had had from government lawyers.
Does that represent the truth?
No, it is not an accurate reflection.
It is not, is it?
No.
Why did you let it stand like this when it was not...
I had legal advice, and I thought that that legal advice was... I assumed it was correct.
It is you who have to sign things, to swear that it is true.
The Scott inquiry has revealed that during the spring and summer of 1991, civil servants' witness statements were passed around Whitehall for suggestions as to content and alterations. Lord Justice Scott, in questioning Andrew Lighthead, one of the key government lawyers, has criticised this practice. Mr. Lighthead had struck out words from Steadman's statement that showed his suspicions.
This was drafting something which, according to its text, related to his personal knowledge.
Yes.
What business have officials got to be drafting something like that?
Well, it is merely suggesting to Mr. Steadman what the correct position would be.
Suggesting what?
Suggesting to Mr. Steadman what the correct position would be. It is up to him to know what was in his statement.
Well, how do the officials know what the correct position is, when what is being dealt with is Mr. Steadman's state of mind?
When you have a witness giving evidence on behalf of the department, many hands contribute.
Why do you say he was giving evidence on behalf of the department?
He is a departmental officer, giving evidence as to what he did on behalf of the department.
His evidence in a criminal case, or perhaps in a civil case too for that matter, is not evidence on behalf of anybody. It is evidence as to the truth as known by the witnesses, is it not?
Yes.
Don't you think at the end of the day that both the ministers and the civil servants had the same interest, which was to keep these documents hidden because of what they might reveal?
What could it profit civil servants to keep it hidden? What possible interest? Civil servants aren't going to fall at the next election. Civil servants aren't going to have been found out to have said one thing in Parliament and another thing elsewhere. So no possible benefit to the civil service. One can see the benefit to government ministers, but I fail to understand why any civil servant should have gained anything.
While witness statements were being prepared, the Sunday Times reported that Alan Clark had given Matrix Churchill a nod and a wink over exports to Iraq in 1988. Senior civil servants met to discuss the article and agreed that their own records showed the message of the Clark meeting to be ambiguous. But later in his witness statement, Alan Clark made no mention of the ambiguity. He told Lord Justice Scott that at the meeting he was protecting intelligence sources by not making clear, either then or in his witness statement, the government's knowledge the machines were for arms.
Were you concerned, though, when you were signing this document, 345-346, that it did not actually set out what happened at the meeting?
No, it sets it out all right. It sets out what happened at the meeting. I can't see any respect in which it doesn't. It omits my knowledge.
That is right. It omits the government knowledge, does it not?
Yes. I suppose I should have insisted that I don't know what.
Well, there is unquestionably evidence of witness statements being taken which represent less than the whole truth. There are significant omissions which are so gross as to amount to distortions and to become misleading.
How do you feel as the lawyer for the defence that happened?
Well, it's an outrage, quite frankly, that a prosecuting authority can come to a theory about a prosecution which they know does not represent the reality of what happened, and then proceed to massage the evidence to fit that theory.
The prosecution had got their witness statements, but the defence knew that inside Whitehall there were documents vital to their case, showing the government knew what the Matrix machines would be used for. However, the government tried to prevent these papers from being revealed. They used a powerful legal weapon. public interest immunity certificates, orders signed by ministers preventing the defence getting hold of the documents.
Danger is never very remote from the submarine service when the underwater vessel dives and fails to rise again.
Wartime Britain. A lost submarine leads to a landmark case. Relatives of seamen killed tried to make a claim, but the courts used a public interest immunity certificate to withhold government plans revealing the design of the craft. The public interest immunity certificates protected national security.
It's a very, very serious document. It's not, as some government spokespeople have tried to maintain, a kind of nudge, nudge, mind how you go to the judge. It's not that at all. It certifies as a fact that the revelation of these documents will damage the national interest. And the vice of the PII certificates in the Matrix Churchill case is that we now know that those documents did not damage the national interest when they were revealed. Quite the contrary.
Government lawyers met to decide how to draw up the certificates. When they are used, ministers sign the orders, but a judge rules on whether to uphold them. The certificates covered a wide range of documents, not just intelligence reports, but papers from the ministries too, which revealed the government's knowledge. The certificates were drafted with strong warnings to the judge. The Attorney-General, Sir Nicholas Lisle, hadn't read the documents, but demanded ministers sign, claiming national security was at stake. Ken Clarke, then Home Secretary, signed too, covering intelligence information only. Disclosure, he said, would help hostile powers willing to kill innocent civilians. But Tristram Garrell-Jones at the Foreign Office and Malcolm Rifkind at the Ministry of Defence signed certificates covering not only intelligence papers, but a wide range of government documents. It was for reasons of public interest, they said, and disclosure of any part would be objectionable. Some of the documents they blocked have been described by Scott as trivial and innocuous. The Scott inquiry has closely questioned Andrew Lighthead, one of the lawyers behind the public interest immunity certificates, as well as the drafting of the witness statements. The inquiry put it to him that the warnings covering all documents, even the trivial and mundane ones, would influence the judge to believe national security was at stake.
The judge is likely to believe that.
Yes.
He has no reason to doubt it. He has been told it by a minister.
Yes.
He has no yardstick to know that, in fact, these discussions between the officials really would not injure a flea, and it is just because it is convenient.
That is right.
Mr. Lighthead argued that virtually all Whitehall decision-making should be kept from the public.
It is regarded as damaging to the public interest that any of this process should be exposed.
Who regards it as damaging to the public interest that any of this process, in any of these cases, should be exposed? Who?
I think it is a general view of people who deal with this subject.
I did not hear that, I'm sorry.
It is a general view of people who deal with this subject.
The government?
Yes.
The Attorney-General, Sir Nicholas Lisle, told a fourth minister, Michael Heseltine, to sign, but he alone believed it would work against the requirements of doing justice, and he wrote as much on the certificate, emphasising to the judge, as he had been told, it was a matter for the court. He later described Nicholas Lisle's advice on such certificates as incredible. Mr. Heseltine has revealed how at first he simply refused to sign when told to by the Attorney-General.
When I first read this submission, I said, up with this I will not put.
How would you put your reasons for refusing to sign?
That I believe that if we have this evidence of a sort that I am talking about and that I've read out to you here today, it could not be right to suggest that it was not relevant to the defense.
You say, in the Matrix Churchill case, no rational person who had looked at the files could have said that the documents should not have been disclosed. It would have been terrible if a defendant had gone to jail as a result of non-disclosure. Right?
That was the whole basis of what I was doing.
Mr. Heseltine was very uneasy about having to sign such a document.
Heseltine has many virtues, but he's not a lawyer. Lord Justice Scott is supposed to be.
But Mr. Heseltine is a minister, and he was being asked to look at interdepartmental documents, and having looked at them, he seemed aware that they should have been exposed to the defence.
He shouldn't have worried his little heart about them at all, because somebody else has the duty to consider that question.
Lord Justice Scott has described as unreal the way PII operates, giving a minister who is obliged to sign no say in the matter, and he believes the way the certificates were used undermines the chance of a fair trial.
The point is this. The importance in a criminal case of relevant documents, and we're only talking about relevant documents, being made available to the defence, for the defence to make what they will of them in order to achieve justice, is so strong as to make it unthinkable that anybody could ever try to use PII to cover documents of which no more could be said than that they were confidential.
I have an uneasy feeling that that law has not been properly studied by some members of the inquiry.
Are you talking about Lord Justice Scott here?
Well, I'm naming no names.
He has been very critical of the use of public interest immunity certificates.
I think he should have refreshed his memory a little.
Paul Henderson's defence counsel was determined to read the government documents, and in September 1992, as the trial was about to begin, he argued long and loud before the judge that the papers were vital to their defence, that the government knew that the machines were to be used to make arms. Meanwhile, in Whitehall, not everyone was prepared to back the weapon of public interest immunity. It was acknowledged to be covering mere embarrassment. Douglas Hogg, a Foreign Office Minister, advised his boss, Douglas Hurd, that despite what the certificates said, the only issue in revealing the documents was government embarrassment. But, he concluded,
the prospect of embarrassment to ministers is not a good or sufficient reason for withholding the documents.
However, the alternative, abandoning the case, might prove very awkward.
Parliament will really smell a rat.
And so the Matrix papers were released and the defence allowed to take copies. In court, Alan Clark admitted he'd been economical in describing what actually happened at the meeting in 1988. The case collapsed and the Matrix executives walked free. But that might not have happened if another judge had considered the public interest immunity claim.
Justice is not a game. The vice of this case was that ministers and their senior advisers thought that they could play justice as a game. They could withhold this card and play that card.
The abandoned Matrix factory bears witness to the disturbing culture Lord Justice Scott has laid bare.
There is a deep confusion about what public interest is and what government interest is, and they're simply not one and the same thing, but it looks all too much as though ministers had decided that government interest is always, always as important as public interest, and I think most of us know that that isn't true.
And the Matrix affair is also a testimony to the attitude of the powerful towards those they represent.
When you put together all the meetings about Matrix Churchill arms to Iraq that we now know about, thanks to the court case and Lord Justice Scott, there is a spectre hovering over all of them. Political convenience, the avoidance of embarrassment. We don't want a row. We don't want the ignorant and the unwashed to know about this because they're not up to making the fine judgments that we know are involved. It's stamps of not just the convenience of power, but the arrogance of power.
Above all, the inquiries revealed just how vulnerable the ordinary citizen is to Whitehall's philosophy that truth is a difficult concept.